Welcome to all. As a part of the course on Insolvency and Bankruptcy law in India, today we are going to discuss the concept of timelines and persons who are not eligible to make an application under the IBC. So in the previous classes, we have already discussed how to make an application, that is under section 7, section 9, section 10, where under section 7 of the IBC, financial creditor can make an application. Section 9, operational creditor can make an application, whereas under section 10, corporate debtor, they can make an application for initiation of CIRP process. So today, first we are going to discuss the concept of persons who are not eligible to make an application under IBC. So that means under this section, if any person falls under this section, then they cannot make an application under section 7, 9 or 10. So before that, let us discuss the concept of suspension of initiation of CIRP for defaults occurring during the COVID-19 period. So during the COVID-19 period, central government has introduced one section, section 10A, where they have suspended the initiation of CIRP process against any company because of the corona, because of the pandemic period. So there is no business actually. Lockdown was imposed. So that's why central government inserted this section 10A, whereby they have given relaxation to all the corporate debtors. Now let us look at the section. So notwithstanding anything contained in section 7, 9 and 10, no application for initiation of CIRP of a CD shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf. So this section clearly provides that you cannot initiate CIRP process during the period of, if there is any default is there, between 25th March 2022. Now actually when the section was notified, 6 months period is given, or central government is having power to prescribe not exceeding 1 year. So they have utilized maximum power, so whereby 1 year is given. Okay, so from 25th March 2022 till 24th March 2021. Okay, so whenever if there is a default is there, okay, so for such default, you cannot file an application under section 7 or 9 or 10 as the case may be. Okay, now provided that no application shall ever be filed for initiation of CIRP process of a corporate debtor for the said default occurring during the said period. So this section further provides that, okay, so if there is a default is there, so is it temporary in nature? No. So if there is a default is there between 25th March 22, 24th March 21. Okay, so during this period, if there is a default is there, okay, so you cannot file a case for this default forever. So that means this period is totally ignored. I can say this period is totally ignored. That is 25th March 2022, 24th March 2021 is totally ignored. It is removed from the IBC period. So if there is a default is there between these two periods, that is 25th March to 24th March, okay, you cannot file a case, okay, before the adjudicating authority. Then for the removal of doubts, it is hereby clarified that the provisions of this section shall not apply to any default committed under this section before 25th March. Sir, what is excluded from the purview of IBC? Okay, any default from 25th March to 24th March 2021. Okay, so if there is any default is there before this period, that is before 25th March 2020, if there is a default is there, please remember you can file a case for such period. Okay, the period which is excluded from IBC is only from 25th March 2020 to 24th March 2020. If there is a default is there before this period, if there is a default is there after this period, both are included. Okay, we are only excluding the period of 1 year, that is 25th March 2020 to 24th March 2021. Okay, then in one of the case law, that is Ramesh Kaimal versus Siemens Gamesa Renewable Power Limited Private Limited. In this case law, the Supreme Court held that, so while deciding whether to accept the application or not, okay, so section 10A clearly provides that it is totally ignored. This period is totally ignored. This period is totally omitted from the IBC purview. So when you are, when any case is there before you, okay, the adjudicating authority need not to verify the actual financial difficulty or the extent of financial difficulty suffered by the CD. So it doesn't matter whether the corporate debtor suffered the loss or not during the COVID period or not, it doesn't matter. Okay, so because that such period, that is 25th March to 24th March, it is totally excluded. So that's why when any application is there before the adjudicating authority where the due is during this period, that is 25th March to 24th March of 2021, then directly you can reject the application. Okay, so you need not to verify, the court need not to verify whether there is an actual financial difficulties there. Okay, so what is the extent of the financial difficulty, all these things, it doesn't matter. Okay, so it need not be gone into. Okay, so in another case law, plus Corporate Ventures Private Limited versus Transactional Growth Fund Limited. So in this case law, NCLAT held that the default committed during the period covered, that is 25th March 2020 to 24th March 2021. Okay, so cannot be clubbed with the default outside the set period. So as already we have discussed in the previous classes, what is the triggering point? The triggering point for making an application under this act is 1 crore rupees default. Okay, so suppose take the example, before 2020, that is 25th March 2020, there is a default is there. Okay, then after 2020, that is 25th March 2020, there is a default is there. Can you club this amount and that amount? That is, so before the period amount and after the period. No, you cannot club. Okay, so you have to consider only before 2020 only. The default committed during the period cannot be covered, cannot be clubbed with the default. Okay, so that is what held by the NCLAT in the case of Plus Corporate Ventures Private Limited versus Transactional Growth Fund Limited. So you cannot club the default of before 2020 and during the 2021. Okay, so this default cannot be clubbed. Then in another case law, Vishal Agarwal versus ICICI Prudential Real Estate AIFI. In this case law, NCLAT held that the default during the period, that is 25th March to 24th March 2020 to 2021, the default during the period is forever excluded. So you have to forget. Okay, so this is totally forever excluded. It is an absolute bar from the initiation of CIRP. So you cannot club this amount. You cannot do anything. Okay, this period is totally excluded, ignored. IBC, from the purview of the IBC, this 1 year period is totally excluded. Okay, then let us discuss. Okay, persons who are not entitled to make an application. So till now we have discussed, in the previous classes we have discussed how to make an application and who can make an application. That is financial creditor, operational creditor and corporate debtor. Okay, they can make an application for initiation of CIRP. Now under section 11, there are certain categories of the people who cannot make an application. Okay, who are not entitled to make an application under the IBC. Now let us discuss about section 11. A corporate debtor undergoing a corporate insolvency resolution process or prepackaged insolvency resolution process. So as we know that can file an application. Yes, under section 10 they can file an application. But if the corporate debtor is undergoing CIRP process, already CIRP process is undergoing, and there is a prepackaged insolvency resolution process is going on. Okay, so in these two circumstances where CIRP process is going on or PPIRP is going on. Okay, so in the subsequent classes we are going to discuss what is PPIRP, what is the process for PPIRP, procedure and other legal formalities relating to PPIRP we are going to discuss subsequently. Okay, so if any corporate debtor is undergoing a CIRP process or PPIRP process, then in such cases such corporate debtor is not entitled to make an application under IBC. Okay, then a financial creditor or operational creditor of a corporate debtor who is undergoing PPIRP. So as we have discussed section 7, section 9, under section 7 financial creditor can make an application, under section 9 operational creditor can make an application. So in case against financial creditor or operational creditor already PPIRP is going on. So there are three categories of the people who can make an application. One is financial creditor, operational creditor, corporate debtor. So first clause is talking about the corporate debtor. Second clause is talking about first two categories, that is financial creditor and operational creditor. So against them, if prepackaged insolvency resolution process is going on, okay, then in such cases they cannot make an application under IBC. Okay, then a corporate debtor having completed CIRP process 12 months preceding the date of make an application. So once CIRP process is completed against any corporate debtor, then please remember within 12 months, they cannot make an application for CIRP process against another person. Okay, so if CIRP process is completed, you have to wait for minimum 12 months. After 12 months only, there is a possibility for you to make an application for CIRP process. Okay. Then a corporate debtor in respect of whom resolution plan has been approved. So CIRP process is going on. After CIRP process completed, resolution plan is also placed and it is also approved. Okay, once the resolution plan is approved, then within 12 months from the date of approval of the resolution plan, such corporate debtor cannot make an application under this section. Okay. Then a corporate debtor or financial creditor who has violated any terms of the resolution plan. So once the CIRP process is completed, okay, then the COC is going to do the resolution plan. Before that resolution, applicant is going to make an application. He is going to propose a resolution plan. Then it is going to be approved by the COC. We are going to discuss in the subsequent lessons. Okay, how resolution plan is going to be approved and the voting rights of committee of the creditors, everything we are going to discuss in the subsequent lessons. Okay, so the resolution plan is already approved. Okay, once the resolution plan is approved, from such date onwards, within 12 months, you cannot make an application. Okay, for the under section 7, 9 or 10. Okay, then a corporate debtor in respect of whom a liquidation order has been made. So in the previous classes, we have discussed the entire process. Okay. So in that process, generally once the resolution professional is appointed, then subsequently COC will be formed. Then subsequent to that, you are going to invite the people to give the resolution plans. If the resolution plan is approved, then you are going to approve the resolution plan and you are going to implement it. Suppose if you fail to approve the resolution plan, or else if committee of the creditor they were unable to come to the conclusion. Okay, in such cases, adjudicating authority can give the order for liquidation of the company. So if adjudicating authority gives the order for liquidation of the company, then such company cannot file an application under this section. Okay, so such person is not entitled to make an application under the IBC. Okay, then for the purpose of this section, a corporate debtor includes a corporate applicant in respect of such corporate debtor. Okay, so who is corporate debtor? Corporate debtor means a corporate applicant. Okay, suppose one company is there. So under section 10, that X company can make an application for initiation of CIRP against X company only. So that's why corporate debtor includes corporate applicant in respect of such corporate debtor. So because they themselves can make an application under section 10. So whenever they are using the word corporate debtor, it means that themselves they cannot make an application against them. Okay, so that is the meaning of corporate debtor. Next, explanation 2. For the purpose of this section, it is hereby clarified that nothing in this section shall prevent the corporate debtor referred in clause A to D from initiating CIRP against another corporate debtor. So that means, suppose take the example, X company is there. Under section 10, in the normal circumstances, X company can initiate CIRP process against X company. Okay. So if X company is undergoing CIRP, then they cannot initiate CIRP process against X company. But whether X company can initiate CIRP process against Y company, yes. Okay, so for the purpose of this section, it is hereby clarified that, okay, a corporate debtor referred in clause A to D from initiating corporate debtor, that is CIRP process against corporate debtor. So that means, if against X company, that is CIRP process completed. Okay, within 12 months, they cannot make an application for initiation of CIRP process against X company. But they can make an application for initiation of CIRP process against Y company. Okay, so that is the meaning of this section. Okay, now in one of the case law, Manish Kumar versus Union of India, the Supreme Court held that section 11 imposes bar on a corporate debtor, including corporate applicant, for initiation of any proceedings for insolvency against itself, and same is no bar for CD to initiate proceedings against another person. So as already we have discussed in the explanation 2, even in the case of Manish Kumar versus Union of the Supreme Court is it was held that against X company, if there is a CIRP process initiated and or liquidation order is given, then X company cannot initiate the CIRP process against X only. But whether X company can initiate the process against or can make an application for initiation of process against Y company, yes. So that's what they are saying. Okay, so imposes a bar on the corporate debtor, including the corporate applicant, for for initiation of any proceedings of insolvency against itself. Okay, X company cannot make an application against X company, but X company can make an application against Y company. Okay, there is no bar for a CD to initiate proceedings against any other person. So if you are initiating CIRP process against other person, then there is no bar under section 11. Okay, now let us discuss about time limitation for CIRP process. So this is one of the basic objective of the IBC. So under IBC, one of the basic aim of IBC is that you have to complete the CIRP process within the time limitation. So section 12 speaks about the time limitation. Okay, so whether is it followed in toto, in letter and spirit or not, we are going to discuss subsequently. Okay, so section 12 provides that the CIRP process shall be completed within the period of 180 days. So once the application under section 7, 9 or 10 is admitted by the adjudicating authority, then the CIRP process must be completed within a period of 180 days. So maximum is 180 days. Okay, then the resolution professional shall file an application to the adjudicating authority to extend the period of CIRP beyond 180 days if it is instructed by COC by vote of 66% of the voting shares. So is there any possibility to file an application for extension? Yes. Okay, so the resolution professional can file an application before the adjudicating authority to extend the time limitation, okay, beyond 180 days. But provided whenever if he is making an application for extension, it has to be supported by the resolution passed by the COC, or such resolution must be approved by at least 66% of the voting powers. Okay, but so when the application for extension is filed by the resolution professional, okay, so if the adjudicating authority is satisfied the subject matter of the case is such that CIRP process cannot be completed within 180 days, okay, he may give the order for the extension, the duration not exceeding 90 days. So the adjudicating authority can give the extension. Okay, once the resolution professional is making an application, adjudicating authority can give the extension, but this extension cannot be more than 90 days. So that means primarily under the act you are expected to complete within 180 days. Plus if you are making an application to the adjudicating authority, then 180 plus 90. So that is 270. So you are expected to complete the process within a period of 270. Okay. Then above extension cannot be granted once, more than once. Please remember, adjudicating authority is having power to give the extension not exceeding 90 days, but generally such extension cannot be given for more than once. Okay, so generally what they will do is they will give the extension for 90 days at a time. Okay, so that 180 plus 90, 270 days. Okay, there is another section. Okay, in the same section another clause states that the CIRP process mandatorily shall be completed within a period of 330 days. So here you may get a doubt. Okay, so in the previous class it was stated that normal timings or normal time limitation is 180 days. Okay, then if you are making an application to adjudicating authority can give plus 90, that is 180 plus 90. But here if you look at this, okay, CIRP process shall be completed within a period of 330 days. That means they are further giving more 60 days. Okay, 180 plus 90, 270 plus 60, 330, 60 days. Okay, so what is this 60 days? Okay, the CIRP process shall be completed within a period of 330 days from the insolvency commencement date, including any extension of period of CIRP granted under this section and the time taken in legal proceedings in relation to such resolution process of the CD. So here when they are calculating this 330 days, actually what they are doing is, so we have given extension to by 90 days, that is 180 plus 90, 270 days. So within 270 days you have to complete. But there are some instances where some days are excluded. Suppose legal proceedings are pending before the court of law. So until the case is disposed of, okay, you cannot continue the CIRP process. So such period is excluded. Okay, so while calculating this 270 days, some days are excluded. Okay, so even after including those exclusions, okay, the CIRP process must be completed within 330 days. So that is the meaning of 330 days. Okay, so this 270 to 330, that is 60 days, okay, can be used for excluding the dates. Maybe you didn't receive the order copy, okay, or else the resolution professional, the board of directors, they are not cooperating with the resolution professional. Okay, So there are so many reasons can be there for the delay. Okay, so all these things can be excluded. So while calculating the 270 days, okay, even after excluding, okay, so it shall not, including the this 60 days exclusion, it cannot be more than 330 days. Okay, that is the meaning of 330 days. Okay, provided also that where the resolution process of CD is not completed within the period of such resolution process within a period, such resolution process shall be completed within a period of 90 days. So this through Amendment Act 2019 it was stated that, so even after extension of the period, that is 180 plus 90, 270, okay, if it is not completed 270 within 270 days, then before the commencement of 2019 Amendment Act, if there are any proceedings are there, then such proceedings must be completed within the period of 90 days. Okay, so anyway, so we are having still 90 days for more time period can be there. Okay, now let us discuss the judicial interpretation. Okay, in the case of Quantum Limited versus Indus Finance Corporation Limited, NCLAT held that an application for extension beyond 180 days may also be filed after expiry of such period if there are justifiable reasons. Okay, so in the normal circumstances, okay, so as a thumb rule, okay, so within 180 days you are supposed to complete. Okay, so if COC is of the opinion that they cannot complete by considering the technical difficulties, then they have to authorize the resolution professional before 180 day only. That means 180 days you are supposed to complete. Okay, maybe 179th day or 170 days. Okay, you are supposed to authorize a resolution professional. Okay, to make an application for extension. Okay, so as a normal rule, the application for extension shall be made during the validity period. That means after expiry period you cannot make an application for extension. Okay, but there are instances where if it is justifiable, okay, if there are any justifiable grounds are there, in such cases NCLAT held that the adjudicating authority may allow such application even beyond 180 days also. Okay, then regulation 40 of CIRP regulations provides that the COC may instruct the RP to make an application to the NCLAT under section 12, then RP shall make an application to adjudicating authority. Sir, who has to make an application for extension? It is RP. Resolution professional is supposed to make an application for extension, that is 180 plus 90 days. For such 90 days, resolution professional has to make an application. Can he make the application himself? No. Okay, so COC has to instruct. Okay, COC may instruct the RP to make an application. Though the regulation uses the word may, actually it is not the may. Okay, so here COC has to instruct. On the instructions received from the COC, resolution professional, he shall make an application to the adjudicating authority for the extension of the time limitation. Okay, then while calculating this 270 days, okay, so there are certain dates are there, certain days are there which are to be excluded from the purview or from the time of the CIRP period. Okay, what to be excluded? So in the matter of Aniba Subramaniam, resolution professional of Karur KCP Packagings Limited, NCLAT held that exclusion can be granted only to the extent of 60 days. Okay, after the expiry of 270 days. Why? Because as already we have discussed, so extension 180 plus 90 days. So 270 days you are expected to complete. But as a whole, the resolution process must be completed within a period of 330 days. So that means 330 minus 270, 60 days. So when you are excluding any dates, okay, such exclusion can never be more than 60 days. Okay, so exclusion can be granted only to the extent of the 60 days only. Okay, then in another case la, Anil Tayal RP of Horizon Buildcon Private Limited versus COC of Horizon Buildcon Private Limited. So in this case la, NCLAT held that the period lost on account of orders being reserved and pending judgment in related application can be excluded from the CIRP process. So maybe CIRP process is going on and parallel there is another proceedings are there against the company or maybe by the company related to the CIRP process. So if the orders are reserved or if any judgment is pending in such matter, because until such other matter is decided, you cannot continue the CIRP process. So that's why while calculating this 60 days, there is exclusion, you can include those dates. Okay. Then in another case la, Ramachandra D. Chaudhary versus COC of Maharashtra Shetkari Sugars Limited. In this case, the NCLAT held that they have excluded the period lost on account of non-cooperation. So there is a possibility once the resolution professional is appointed, as per the law, the promoter group or the board of directors, suspended board of directors, they are supposed to cooperate with the resolution professional. But there are instances where the promoter group may not cooperate with the resolution professional. Okay, so the period where there is a non-cooperation is there. Okay, such period can be excluded from the CRP period. Okay, then in another case, la Ashish Chaturvedi versus INOX Leisure Limited. So in this case, la NCLAT held that period lost on account of delayed communication CRP admission order, the IRP was excluded from CRP period. So generally, when CRP process was initiated, that is when you are making an application under section 7, 9, 10, okay, adjudicating authority will give the order for admission of the application, okay, provided conditions are satisfied. When application is admitted, this information shall be given to IRP immediately. So if there is a delay is there in informing the IRP, then such delay period must be excluded while calculating this 270 days, okay. Then in another case, la Committee of the Creditors of SR Steel India Limited versus Satish Kumar Gupta. So in this case, la the Supreme Court held that the tribunal has the power to extend the time limitation further 330 days. Okay, so as per the law, it has to be completed within 330 days maximum. So tribunal, whether tribunal is having power to extend the time limitation beyond 330 days, can they exercise judicial discretion? Yes. They can exercise the judicial discretion, but it shall be exercised sparingly and judiciously. Okay, so keeping in mind the objects of the IBC. So one of the objective of IBC is to settle the matter quickly. There is CRP process must be completed within the time limitation. So by considering the object of IBC in exceptional cases where in the interest of the stakeholders, if the tribunal is of the opinion that you have to give the extension beyond 330 days, then there is a possibility they can give the extension beyond 330 days also. But it is only an exceptional case, please remember, okay. You cannot use this power regularly. In exceptional cases only you can use this power. So on lapse of 270 days, in the absence of the COC resolution requesting further time, okay, generally the COC has to make a request for further time, as already we have discussed in the case of Committee of the Creditors of SR Steel India Limited. In exceptional cases, NCLT can give the exception, extension. Okay, in the absence of any application made under for the extension beyond 270 days, in the normal circumstances, okay, if you fail to complete the CRP process, as a thumb rule, liquidation shall be ordered. So as already we have discussed, okay, so when the liquidation order will be given, if you fail to complete the CRP process within the time limitation, or if the COC decided to go for liquidation, or if you don't receive any resolution applicant, okay, so in those circumstances generally liquidation shall be ordered. So if you fail to complete the CRP process within 270 days, where COC also failed to make an application for extension, in such cases liquidation order shall be given under section 33 subsection 1 clause A. Okay, so about liquidation we are going to discuss subsequently. Okay, now let us look at the timelines under the regulation 90, okay, CRP regulations. So this is modal timeline given under the regulations. Okay, so T, that is transaction date, okay, section 16 commencement of CRP. Then T+3 public announcement. So within 3 days of appointment of IRP, public announcement shall be made. Okay, then within 14 days, T+14, okay, submission of claims. So submission of claims shall happen within 14 days. Okay, that is 14 days from the appointment of IRP. Then regulation 12.2 submission of claims. So up to 19th, that is T+19. So once if you give the public announcement, then within 90 days, the financial creditor or operational creditor, any creditor, they can submit the claims. Okay, that is T+19. Then T+21. Okay, so regulation 13, verification of claims. So here you have to give, you have to submit the claims within T+14. Okay, so once if you receive the claims, that is T+14. Look at the next slide, T+21. So 14+7. So within 7 days from the receipt of the claims, you are supposed to verify. Okay, verification of claims received under regulation 12.1 or 12.2. Okay, so in case of 12.2, T+97. Okay, why? Because so this is submission of claims Under 12.2 is 90 days, T plus 20. Under 12.1 is T plus 14, okay. So T plus 14 plus 7, that is T plus 21. T plus 90 plus 7. So in both the cases it is 7 days only, okay, within 7 days from the receipt of claim. So under regulation 12.1, actually it has to be received within 14 days. Under regulation 12.2, the claim must be received within 90 days. So from such 14 days or 90 days, as the case may be, 14 plus 7 or 90 plus 7, 21 or 97, okay. Then application for appointment of AR, okay. So within 2 days from the verification of claims received under the regulation, okay. So 21. Reporting certifying of AR, okay. So even in this case also T plus 21, 23, okay. Then T plus 30. So first committee of the meeting, COC. First meeting of the COC must be conducted within 30 days, okay, from the date of commencement, okay. Within 7 days of the filing of report certifying the constitution of COC, okay. So you have to constitute the COC. As already we have discussed, COC resolution professional is going to constitute the COC. Once it is constituted, then within 7 days you are supposed to conduct the meeting, okay. Then T plus 30, resolution to appoint RP, resolution professional by COC, okay. So in the first COC meeting only they are supposed to appoint, okay. Then appointment of RP. So as already we have discussed, T plus 30, but it will come into effect from there is no time limitation. So once the adjudicating authority gives order, immediately it will come into picture, okay. Then T plus 40. IRP performs the functions of RP till RP is appointed. Okay, so if RP is not appointed by 40th day, that means 10 days time limitation is there, okay. 30. So resolution to appoint RP 30. Then 10 days time limitation is there, that is 40th day. Within 40th day, okay, if RP is not appointed, then IRP will continue, okay. That is T plus 40. Appointment of valuer. So within 7 days from the date of appointment of RP, that is 40 days, 40 plus 7, so 47 days, okay, T plus 47. Then next W, okay, submission of application for withdrawal of application admitted, okay. So withdrawal is denoted with W, okay. So before issue of expression of interest, that is whenever if you want to withdraw the application, then before issue of expression of interest only you have to withdraw, okay, that is W. COC dispose of application within 7 days of its receipt or 7 days of constitution, okay. So when COC has to dispose of the application, that is W plus 7. Then filing of application of withdrawal, okay. So if approval is by 90%, okay, whenever if you want to withdraw the application, then 90% majority is required, okay. Subsequent lessons we are going to discuss about the withdrawal of application separately. So where we are going to discuss the legal rules and regulations, okay, within 3 days of the approval of the COC, that is W plus 10. So this is only withdrawal, so that's why W plus 7, W plus 10. Then again come back to original time limitation, okay. So RP to form an opinion on preferential or other transactions. So preferential transactions are there, then those transactions can be excluded, okay. That is within 75 days, T plus 75. Then RP to make a determination on preferential or other transactions, okay. Then it has to be done within 115 days, T plus 115. Then RP to file applications to adjudicating authority for appropriate relief. Suppose if any preferential transactions are there where the money is siphoned, okay, siphoning of the money is done, then in such cases RP can file an application to the adjudicating authority for the appropriate relief, okay. This has to be done within 130 days, okay, from the commencement. This is about preferential transaction. Now submission of IM to COC within 95 days of the commencement, okay. Then publish the Form G. Form G is for announcement, okay, public announcement, okay. So publication of Form G and invitation of expression of interest, submission of expression of interest. Though this publication must be done T plus 60, submission of expression of interest T plus 75. Then provisional list of resolution applicants by the RP is T plus 85, okay. Then submission of objections if any, T plus 90. Then final list of resolution applicants by the RP, then T plus 100, okay, that is 90 plus 10, T plus 100. Then issue of RFRP including evaluation matrix and IM, then it has to be within 5 days, that is T plus 105. Then receipt of resolution plan, it has to be done T plus 135. Then submission of COC approval, resolution plan is submitted, it has to be done, it has to be approved by the COC, that is T plus 165. Then it has to be submitted. So approval of resolution plan by adjudicating authority within T plus 180. Okay, so these are all the various time limitations. So whether these time limitations are strictly followed or not, just now we have discussed. So 180 is the time limitation. There is a possibility it can be extended by 90 days, that is 180 plus 290, 270. But another section says that it has to be completed within a period of 330 days. Okay, so in this lesson we have discussed who is not eligible to file an application under section 7, 9, 10. Okay, then subsequently we have discussed the time limitations, that is 180 plus 90 then plus 60. Okay, while calculating the 60 days, certain dates can be excluded. Okay, what can be excluded, those things we have discussed, and model time framework prescribed under the regulation. Thank you.